Retirement in divorce is not a topic anyone likes. Not the divorcing couple, not their lawyers, not the courts. Retirement involves complex financial and tax issues that are hard work and no fun. Retirement often isn't on your radar when other more pressing issues of child custody, division of debts, the payment of alimony, and other things are vying for your immediate attention. And sometimes people think that they get to keep their retirement accounts without sharing with their spouses, so they don't think retirement is a divorce issue. As a result, division of retirement funds can and often are not given the attention they deserve, and you can end up with a division of your and/or your spouse's retirement funds that you neither wanted nor understand, and without even knowing it. Retirement assets are in some ways like any other marital asset. They have value, and they need to be divided. But retirement assets can also be kind of special, especially if they end up being your most valuable marital asset or if you divorce near retirement age. We usually think of our houses as being the most valuable thing, but retirement plans, especially as you grow older, can become more valuable. Don't assume that you're best off keeping the house while your spouse keeps his or her retirement. Compared with retirement savings, a home is more likely to have ongoing and unexpected expenses, and its future value and liquidity are more complicated. Sometimes you can offset the value of your retirement against other marital assets so that you get to keep your retirement account completely intact. Other times, however, there simply aren't enough offsetting assets, or your spouse may not want assets to offset his or her access to the cash in your retirement accounts. Remember also that different kinds of retirement accounts receive different tax treatment. Pre-tax accounts like a 401k or a 403b or a regular individual retirement account, or IRA, these are taxed when you withdraw money in retirement. Roth IRAs aren't taxed when you withdraw the funds at retirement. So if you have $200,000 in a 401k and your spouse has $200,000 in a Roth IRA, and then both of you decide to let each other keep the account in his or her name, that won't result in an equal division of assets because of the different tax treatment. Most people aren't aware of the one-time opportunity for a divorcing spouse under age 59 and a half to withdraw money from his or her ex's 401k or 403b without owing the normal 10% tax penalty if the assets are allocated under the Qualified Domestic Relations Order, or QDRO. But if you want to or need your share of the spouse's retirement account now to pay for some expenses, you can do that too, although that will result in a 10% early withdrawal penalty if you're under the age of 59 and a half. 401ks and IRAs are known as defined contribution plans. They are essentially savings accounts and divided by splitting money up between spouses. But there are also defined benefit plans. They are not accounts into which your employer deposits money over time. Defined benefits plans are more expensive for employers to maintain, and so they are becoming more rare. But the important thing to know about defined benefits plans are that until you are vested in the plan, you have no right to any money. If you leave your company before retirement age, you can take your 401k or an IRA with you, but your defined contributions plan isn't portable. Yet in divorce, your share as a spouse of a defined benefits plan can be awarded. But because defined benefit plans can't be valued based upon actual dollars in the present, they are more difficult to evaluate in divorce. Valuation of the plan may require an expert to ensure the division is fair and enforceable. This video is just an introduction to the effects of divorce on retirement. Please take advantage of other videos, articles, FAQs, and forums about identifying, valuing, and distributing retirement benefits.